Oh, hello. I didn't see you there. I was just doing some light reading of our nation's seminal documents when I came across this. A small and perhaps overlooked part of our Constitution, overshadowed by the more controversial and consequential amendments that make up the Bill of Rights. But perhaps there's something in these modest lines of legislature that we've overlooked in our past examinations of the Constitution.
In suits at common law, where the value in controversy shall exceed $20, the right of a trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law.
To put it simply, this is the amendment that gives the participants in a civil court case the right to a jury trial. Today, I'd like to examine this amendment piece by piece. Join me as we uncover the mysteries of this undeniably essential amendment.
Let's begin with this section.
Now, I know what you must be thinking. There's a part of this amendment that immediately stands out as oddly specific. Why common law? Why suits at common law? Why not uncommon law, or legal law, or chartreuse law? Great question. This phrase has to do with the Founding Fathers and the context in which the Seventh Amendment was written. You see, common law refers to English common law, which is the system of legislature that governs the English court system, and it applied to the American colonies. The framers of the Constitution were influenced by this English legal infrastructure. It served as the basis for the judicial branch and many other parts of the American legal system, including the Seventh Amendment. In suits at common law means in suits in which a jury trial applied according to English common law. This is interpreted as civil cases. Civil cases are court cases in which neither of the involved parties are governments, unlike criminal cases, in which the government prosecutes an alleged criminal. To put it simply, they're lawsuits. Now, there are some other limitations on the Seventh Amendment. The Seventh Amendment only applies to federal courts, although all of the states, with the exception of Louisiana, have implemented laws that allow for juries in civil cases.
The value in controversy shall exceed $20.
James Madison understood that trials were time-consuming. In order to save time on what would otherwise be spent on inconsequential trials, James Madison added this condition. Back then, $20 was a significant amount of money. Nowadays, all it's good for is ruining the library TA's day. Today, federal courts will only accept cases where the value in question is at least $75,000. Additionally, judges will try and encourage the involved parties to settle outside of court. Our next section has to do with judges.
The right of a trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law.
This section of the amendment is meant to do two things: strengthen the power of the juries and limit the authority of judges. See, the jury was very important to 18th century Americans. Jury nullification was a key method of rebellion against what the Americans saw as English tyranny. Jury nullification is where the jury in a criminal case declares the defendant innocent because they believe that the law they broke was unjust. The early Americans were also wary of judges because during the time leading up to the Revolutionary War, judges were often loyalists that would rule in favor of the English crown in courts. They, having seen the power of judges mishandled, people wanted to make sure that judges would not grow too powerful under the new American government. It's important to know, however, that there are certain situations in which a judge can throw out a jury's decision. In Slocum versus New York Insurance, the court ruled that a judge could overturn a jury's decision if it ran contrary to the evidence presented in the case. So that's how the Seventh Amendment works. Now, I'm here in front of the offices of Dr. Farnsworth to talk about contemporary controversy surrounding the Seventh Amendment. Hello, Dr. Farnsworth. Thanks for meeting with me. It's a nice place you have here.
It's my pleasure.
So, Dr. Farnsworth, what do you think of the Seventh Amendment? You know, we interpret that line in suits at common law to mean civil cases, but is that really how English common law worked? Should we re-examine that? And like this number, $75,000, like is that, should we hear cases that are like dealing with less money than that or more, or like is that a good number? Should we change that? What do you think? What do you think?
Well, I don't think we should have a Seventh Amendment at all.
Oh.
I mean, there's just so many problems with jury trials. Jurors are often unexperienced in the legal field, so they're bad at understanding evidence. Judges aren't allowed to summarize any arguments or explain any evidence, so jurors often misunderstand things. As a result of this, most people will waive their Seventh Amendment rights because they want their cases to be decided by judges. And as another result, less than 1% of civil cases are decided by juries.
Well, I appreciate your candor. Now, you might be wondering what I'm doing in the wild jungles of southeastern Botswana. Great question. You see, Botswana, like so many other countries, doesn't have civil cases decided by juries. This is a land without the Seventh Amendment, a savage and untamed place. Botswana is not actually a savage place. It's quite nice right now, actually. You know, maybe the Seventh Amendment is irrelevant in modern times, but I think that might be a good thing. It was important to a group of people who were fighting tooth and nail against a tyrannical despot. I think it's good that maybe their experience isn't so relevant to ours today. I guess what I'm trying to say is, next time you go to jury duty to decide whether or not Walmart is responsible for the injury of someone who slipped on a sidewalk outside of one of their locations, think about the people that went to war to decide whether or not they could secure the blessings of liberty for themselves and their prosperity. Hello? I hope
hope that you enjoyed my little video about the 7th Amendment. I'd like to take this moment to talk about my personal opinion. It's true that less than 1% of civil cases are decided by jury. I think it's the sad fact that the plaintiff and defendant don't want a jury in the courtroom, and the jurors don't want to be in the courtroom. So people often decide to waive their 7th Amendment rights. I am very glad, though, that the 7th Amendment is there for those few cases when we do need it. This is a not-so-current event, but a few years ago, there was a woman who sued McDonald's after they served coffee that severely burned her. People often use that lawsuit as an example of a frivolous lawsuit, but that woman was elderly and she had very severe burns. And in that lawsuit there was a jury, and I think they had sympathy for her plight, and they made a verdict in her favor, and she was awarded a tidy sum of money. I think that's a case where the 7th Amendment did real good. I'd like to thank you for watching my video again, and I'm sure if Christine were here, she would thank you too, and me, for doing the whole project without her.